Yes, pass on all the memos.
One matter, your lordship, with your lordship's leave, my lord. One matter, my lord, prepone the hearing by file an IA because they are going to implement the impunity judgment.
Yes.
Item number 1.
Pass on the slip. No mention here.
Lordship's list here.
Yes.
Item number 29. Kindly seek to withdraw. And the petition seeks to withdraw the writ petition.
File the memo.
We'll file the memo.
Other side.
Means that the municipal corporation.
Cuttack Municipal Corporation, they have separate panel of council.
No order is passed, so what is the difficulty? We want to withdraw. Yes.
Who has listed? Here is the case, madam. Work involved to the amount of 4,87,000 has been completed in all respects. What?
Yes, yes. All their certificates and all, everything. This is that matter, yesterday's matter.
Yes.
All the certificates are there, everything you have. Only thing is there was no fund. They could not release. Then how can you withhold the money? If he has.
That is not the fact.
That is not the fact. Sir, all these documents, are you disputing that these are all fabricated documents, manufactured document?
Not that.
Can you? Then how can you deny? Where are those letters, the certificate that everything is completed, satisfactory?
Yes, sir.
Bottom serial number 2 US, if I correctly remember.
Next 3 lordship list.
At the bottom, second work, yes.
And lordship, the first paragraph, last lines. As the following works has been completed in all respects. As this serial number.
Yes.
Serial number 2 from the bottom works.
Work completed. What more?
Lordship, kindly have the clients to page 20, annexure 3 by 5 to our counter at 25. I'm just taking to the document.
This is a letter dated 12/4 and you are referring to 28/3, previous order. Yes, previous application, the letter.
This is subsequent.
24.
Oh,
24 minutes.
okay.
Now the superintending engineer, who is the signatory in annexure 3 minute, he has written to the chief engineer to withdraw that amount.
Yes.
Director, let's say, can have a glance to the next page. Next page relevant portion is the second paragraph.
Yes.
Then we have next page 26. At column serial number 1. That is the work minute and the remark column not the kind have a glance.
Not rectified the work. Then
Yes, minute. Thereafter, yes, I'm okay. Thereafter, minute. 2 letters were sent to me to the contractor at page 27 minute and 28. He received it and thereafter no response. And this ground is not taken in the requisition.
sir, if that being the position, then you go file a suit for recovery.
National submission is not received, lordship.
Yeah.
Kindly see. I'm answering all these points, lordship.
Yes. You should answer when they wrote a letter,
No,
you should answer
yes.
there.
It was sent by email.
Lordship is a completely misleading, lordship, I'm sorry.
Misleading. Let us.
Yes, lordship.
Yes.
Annexure 7, lordship, kindly say, my regional representative. And it's 7 page 5.
Yes.
This is your lordship, my agreement stipulation date is 23/6/2022. On that date, I have completed work. This is the certificate issued by the
When? 2022, sir.
23/6/2022 is the work completion date.
I am asking, sir, subsequent thereto, they have inspected the work and found that you have not
Yes, I'm
completed.
answering. There's the lordship, kindly see page 8, annex 9. This is the standard operating procedure, lordship. Is issued by the works department, lordship, the relevant portion kindly see.
Yes,
Lordship will find at page 10. This is the procedure for release of final bill, lordship.
yes,
May I place, I am permitted to place, lordship.
yes.
All eligible payments due to contractor of the work done, services rendered and materials delivered should be promptly settled. In all cases, the payments must be settled within 16 days. After satisfactory completion of the work, unless otherwise mentioned in the free contract. Lordship, thereafter, lordship, kindly sees IV. IV, processing of mandatory additional documents like extension of time, variation, revised administrative approval, etc. The division of this and approval by the competent authority if required before processing the final bill, along with provision of allotment authorization for payment for fees and payment in the division of that is lordship T plus 60 days. 60 days means the period of agreement. Or if UT is adopted, then the extension period plus 60 days. My lord, within 60 days, we have on the date of completion work, their officers given this certificate. Everything, 3 or 4 letters are on the record that they have certified that all work is completed. After 1 year and 9 months, within 60 days, they have not raised the objection. The same authority who has stated to be objected on 28/3/24, he himself retained in the annex 3 and annex 8 to the regional affidavit, that work has been completed in all respects. After 1 year and 9 months, this officer again, when I raised for payment, found was available giving the payment, that was not released. And this is the subsequent development. They have not raised the objection within 60 days. They have accepted the reports of the subcontractor officer. Lordship, so far as the letters they have stated, lordship, I have not received any such letter. So far as the register letter is concerned, they have not appended even the undelivered postal box. They have not annexed, lordship. And the mail, lordship, kindly see, this I have taken instruction from my client. So he has not received any mail. Lordship, this is the mail confirmation report. This is whatever has been given. This is not the mail confirmation report. He has not received the mail, lordship. And lordship, the
Show us the email,
Email
3/5. The email is of 3/5.
email, lordship, will kindly see, I'm not sure of the counter affidavit.
Where is the,
Email, lordship, page 28, G/5. This is, lordship,
but
not.
where is the, at the top, there is some indication of the email delivered on.
Mail confirmation report is not, this is not the mail.
Is
confirmation.
this, the email address is of yours?
Yes.
So there is no question of any bouncing.
Might not have delivered to spam. It might not have been delivered. Must have been gone to the spam. That's really happened, but this mail I have not received.
So spam, you can always, what is spam? Spam you can always view
Before delivery, lordship.
before delivery. Always when the email is given, either it goes into a directly inbox or in a spam, you can definitely say, because the pop-up that comes.
I have not received, lordship, by the register.
Oh, that will not do, sir. One presumption has to be taken into account. If it is if the email address is correct,
Yes, lordship.
and if they say that they have uploaded, then whether it has gone into a spam file or it has gone into a inbox file is something which is your email. How you have?
No, I have checked also spam. I have used
Sir, there are apps where you can in a email, and this is a Gmail, and the Gmail there is an app which says that any official correspondences will not go into the inbox, may go to spam. So it is up to you how you have adjusted your mail.
Spam, I have checked, it has not been gone to what I am submitting lordship. Before delivery, it might have gone to spam of their.
Sir, if the email address is correct, either there are two possibilities. Either it is presumption is it has gone, or there is a possibility it bounced back.
Yes.
And if it is bounced back, then it will not show. It will definitely, it will show that it has bounced back.
Because I,
Huh? No, it bounced back. This is not delivered.
and why I am submitting lordship, because on the 28/3/21, on the date when the fund was available for release, same day joint verification was done. And without giving me any notice lordship. Why I am saying this? On 28/3,
That is you go, this is a matter of, huh?
no lordship, Alice is a small
Huh?
amount lordship. See, everything admitted, how can they revert back lordship?
We are not going into a very intricacies of law, whether a writ purely in the nature of recovery of money is maintainable. Purely, I'm talking about pure. I am conscious of ABL international judgment. I know there is no difficulty. There are other judgments which says that yes, the writ of such nature, but then there is a composite one. Then, if it is purely, we are not going into this. Yes, which one?
I will take instruction regarding this.
What? You will consult law with your client.
No, regarding that.
You know, huh?
Sufficient address, checked up. The mail document. The check address and the address given in the.
I have already represented the higher authority on that issue. We will have to take a final decision. On instance of 6, I have already represented the authority. That's they let the final decision because it is what
I have a strongest of reservation on creating a cause of action for another litigation. I will not direct simpliciter to consider the representation.
reason I have
No, sir.
reason of non-release also have indicated in page para 11.
You go for a suit, produce an evidence, give an evidence, everything will be there. There will be a commission, they will go inspection, everything that will be done there. That requires an evidence to be gone into. But in this scenario, what to do? What to do? Your right is not curtailed because 23, still you have a 3 years period of limitation, no problem. Up to 2026 you have.
Handed over in 2022, Lordship. The rectification, they are stating that
They are admitting their liabilities by giving the certificate of completion, but they have raised the dispute. So when they have denied, the limitation has to be counted.
Denial, Lordship, they have not objected within 60 days, Lordship, and that the agreement also does not show that after 1.5 years they will raise an additional application. And whatever the agreement they have relied upon, that is the post detection of the rectification period, not prior to that. Prior to that, there is no indication that such period will be the concerned authority will visit, or everything is done by the subordinate authority, and he has accepted within 60 days, no objection, Lordship. And 1 year 9 months, the work also handed over to the authority. Now,
Yes.
I do not know what is the condition of that is after 2 years or 2.5 years, Lordship. And that the contractual matters, Lordship, Your lordship, recent judgment of the
Hmm?
recent, our High Court judgment, it has remitted back to this for
Who?
sharing. That is the,
What our High Court remitted back to this court means?
our High Court judgment is remitted back by the Supreme Court for sharing because
Where? In this matter?
no,
So,
it's
sir, again I'm saying, there is no quarrel on a proposition of law, but it all depends upon a fact of each case. Have you read this judgment? What I say is really reflected in a very lucid manner. The same observations which I have made is reflected. What to do? It really goes against you. Before citing a judgment, you should go through it, whether it will match with the facts. Simply, the parties have exchanged affidavit does not mean the High Court will decide all the questions. The court has said that the High Court must record that what are the issues which requires to be decided on the basis of an evidence, and will record that once the dispute as to the completion of work is raised, then it's a commission which is very much necessary to go. And can a writ court appoint a commissioner and go and decide this matter in this way? Under Order 26, Rule 9. And this was a case where it was already a time bar, 10 years. Then say relegating the parties after 10 years is not appropriate. Here you are within the limitation period.
that's why I will be permitted to approve the authority consideration.
And this is deprecated. The same view which I expressed is deprecated. This is what is there. The court has said, no, you should not relegate the parties to authority. I know, that's why I'm saying. Before citing a judgment, you should carefully read it. That whether it will be a boomerang or
I will go through the further point of view, or later next time.
it is.
Yes, I will further go through the,
Further go through. I have gone through within a minute or two,
yes.
and I will rely on this judgment. No difficulty. Very respectfully rely and say that binds me.
But I want to know that your lordship decide that this is the case. How a small contractor is suffering what is the small amount. After 1 year and 9 months, they are raising the objection. Which I think afterwards.
No. Once the court has shown that he is not agreeing with your argument, that means an adjournment. That I do not. You came. Yes. What do you have to say?
they may decide.
A subsequent change of opinion without any, by the same authority. Can you prevaricate your stand at the subsequent stage? Can you blow hot and cold? Till this time I was against him. Now I am against you. Tell me.
Whether it is completed or not, it is to be verified.
And the same authority in 2023 gave a certificate that it is completed in all respect. What was he sleeping in a comfortable atmosphere and gave that certificate? No. The certificate must have been issued after inspection. And at that point of time, if they found that every work is complete, later on after 1 year, can he change his stand and say the work is not complete? I'm just asking. Can you? Same officer.
Certainly it cannot be.
So,
What my lord,
so how can you raise? That shows that your inclination is not to make the payments.
my lord, page 13 my lord, of the counter affidavit can have a transfer.
Yes, we are
And that is the part of the DTC only. And that is the part of the contract my lord.
Sir, what is the part of the contract? In a very common normal parlance, in a commercial world, a person is entrusted to do a work. If he has completed a work, then the authority must go and verify that the work is completed in all respect. The moment the work is completed and a certificate is issued for completion, can you deny the payment? I am asking.
My lord.
Later on, can you change your stand?
My lord, this thing happened my lord actually.
You are talking about DTC and there cannot be any clause that if the work is done satisfactorily, the authority will withhold the money. I do not know if this is the clause. It is unconstitutional, unethical.
Actually, my lord, what happened, let's say kindly don't think. Page, their document on which they submitted the certificate, my lord. I'm coming to that. Page 15, let's say kindly have a glass full.
Yes,
Page 15, my lord.
yes,
One page. And
yes. Who has given this?
My lord,
This certificate has been given by the authority.
I'm asking him. I know who is the authority, given by whom, I understand.
So,
I'm asking him a question, sir. Yes.
Dear my lord, this
Yes.
annexure 2 Miller that was submitted by the petitioner himself
Correct?
in form number M Miller.
Yes. And the subsequent
Lordship, kindly,
annexure 3 comes. Subsequent letter, annexure 3, is issued by the office of the superintending engineer,
Yeah.
then the mechanical division on 12/4/2023, addressed to the chief engineer. Then the first opening line is that in inviting a kind of reference to a subject cited above means issue of allotment of fund through IOTMC for the year 23-24 towards the mechanical works. Then say it is to intimate that the allotment for an amount of rupees 2 crores and odd may kindly be placed in favor of this division as the following works had already been completed in all respect. And then the nature of the work is given. And if you come at page 18, the drainage system, Jagat Singhpur, serial number 2, is he who has done it. And the remark column is work completed. If that is the letter issued by a office of the superintending engineer, whether at a later point of time you can raise the objection that the work is not completed.
my lord, It only happened, let us see, kindly have a glance for a moment, page 10 of our document. Page 10. Serial number 16.
Yes,
Serial number 16, let's see.
correct.
Photographs shall be taken prior to commencement, during execution, and after completion of work. All such photographs shall be appended by the successful bidder, along with work completion report obtained from the concerned civil authority as per pro forma form number D during submission of final bill.
Have you taken this particular plea that they have not submitted the photographs and they have not submitted in Form D? You have said that the work is not complete.
Form D, it's not.
They have not, please take, you have said that they have not taken, they have not consulted the assistant engineer, they have not taken care of the specification. Does it come under clause 16? I am asking. Had your stand being that this as per clause 16, you'll have to annex the photographs along with the bill, and that too in a prescribed form. Unless you submit, we can't process your work, payment. Have you taken that plea? No. No. You have taken a plea, work is not complete. He has not followed the specification. When that letter of the superintending engineer says that the work is completed, everything is done. Is it not a sham defense which you have taken before us? Can we not declare it's a sham defense?
They did produce the Form B.
You have not taken a plea, sir. I could appreciate your stand that you have taken, that in terms of this clause 16 you have not followed. You never, not a whisper anywhere in your letter you have said about this.
We have only stated that it's not.
Can you change your stand at the bar if the authority has taken a particular stand? I'm talking about M.S. Gill judgment and subsequent judgment. You as a counsel representing an authority cannot improve the case, nor can take a different point if your authority has not taken such points.
No.
Supreme Court is very categorical in this. Only exception was that's the Bihar CBI case of this I think the mass copying and the leakage of the question paper. That was the only exception. Supreme Court departed from M.S. Gill. Otherwise, till today it is for it. That was an exceptional case. You can't say, sir. You can't. Your authority have taken a particular plea. Can he, I'm asking, change his opinion? That too after 1.5 years or 1 year. When this document is absolutely clear that the work was completed, they ask for a fund so that they can make the payments. No, sir. And this is a paltry sum, sir. What are you doing? I could understand there is a huge amount of money where you can definitely raise certain questions. These are the very fringe paltry sum of a small contractor worth 4 lakhs only. Worth 4 lakhs only. Just imagine. You can't. Look at it, you are fighting for such a small fry for 4 lakhs rupees.
4 lakhs. But I'll take instruction. I got the point. One authority says that it was completed and another one.
No, same authority, sir. That is a astonishing factor. A same authority 1 year before says work completed. And after that 1.5 years, now he is saying no, work is not completed. Can he say so?
It is from Works Department. But I'll take instruction.
If you
Let
compare
it come
page
next
18,
week, Lord, if it is due.
if you compare Annexure 3, the signatory is the same signatory with that of Annexure C/5, Annexure D/5, Annexure C/5 and D/5, your document, same officer.
He can disown.
Within 1.5 years.
He can't. Unless, and that too after 1 year or 1.5 years.
But that's a breach.
No, there is no breach.
This-
Please show him that letter of the superintendent engineer. Where is that letter? That he wanted a money to be given.
Annexure 3, Lordship.
Annexure?
3.
Show him this letter. This is a very interesting letter of 12/4/2023. Has he been given? Have you been given? Annexure 3 to the red petition. Look at the very first sentence. Who is issuing? Office of the Superintendent Engineer, Mechanical Division. In inviting a kind reference to the subject, it is to intimate that allotment for a fund of rupees 2 crores, such and such, may kindly be placed in favor of this division for the financial year such and such, as the following works have already been completed in all respect. And then if you go at the bottom, the last block, that is a drainage division, Jagat Singhpur. The second number is he. And the remark column is work completed. Have you got that second column? Fabrication or something? 4,86,000 and then work completed. That's the remark.
At page 18, serial number 2. I got it.
Yes, serial number 2.
And there also he writes work.
Work
But I'll
completed.
take instruction.
So he is a superintendent engineer who have written this letter. And then later on he has
Your counter C/5 and.
give him a counter C/5. That is nearly after a year. That is after a year. Your serial number is
Lordship.
1.
My serial number is page 16, Lordship.
No. Or their counter. Or paste. Which one is his serial number? Counter, which is 22/4 after 1 year. Which one? Serial number 1, 2, 3? Anyhow, we take any one of them. Not rectified the work as per agreement. One year, exactly after 1 year. And then say work is not complete. And if you come to next page, 27, very, very interesting ground is given.
Similar one. And this is Lordship. This is defect liability period of 1 year. Maybe I have to check. There is in every agreement.
Mr. Advocate General, no. I would not accept this contention. I know in every public contract, there is always a clause that in the event if it is found that there is a defect, then in that event, the liability has to be foisted upon them to do it. Cannot be. The question is of a work, the completion. Once the work is completed and the authorities found that the work has been completed, the only thing is that later point of time, if they raise a question that the quality of the materials which you are supposed does not appear because there cannot be any expertise. So 1 year liability has to be there to amend it. It was not. If you look at the ground, if you come to page 27, but if you read this, but during the joint inspection of the above work on 28/3/2024, that is 1 year after the work is completed, by the superintendent engineer, same officer, joint such and such, it is found that the works have not been executed as per the provision and specification in the agreement. Provision and specification. Moreover, it is mentioned that you have neither consulted with the assistant engineer nor intimated him during the execution of the work. This is what you wanted to take a clause. Further, you have been directed by this office to attend the rectification work. If you have found that the work has been done as per the specification, completed, and gave a certificate, can you change your view? Had it been a defect in the use of the material, in the use of something, that we find that a particular portion is piling off, then you are required to amend it.
Let me. Your Lordship may kindly refer to these two letters. Your Lordship is absolutely right that one superintending engineer has said it is completed. I don't dispute. Because it's on record, it's a fact which is on record. I can, but your Lordship may kindly look at meticulously these two annexes. D/5, your Lordship may kindly come to page 25.
No, I am there.
No,
I am there at 25.
I'll show only two documents.
Yes.
30th March 2024. That is 12 within the period of 1 year of defect liability. Suppose your Lordship may kindly let me explain. If it is due, my Lord, it would be I have to seek instruction on that. But your Lordship may kindly, there is no change of stand. It is completed, but it is not completed in consonance with the specification of the agreement. That is what he said. He doesn't say it is not complete. Your Lordship may kindly read D/5.
I am at.
Lord, I am reading it.
I have seen, but during the joint inspection,
been executed.
I have seen during the same letter.
It has been executed. Maybe it is completed.
No, sir.
But it has not been completed as per the specification.
Then how he has given a certificate for release of the payment? Please look at that letter.
No, Lord,
He wanted that these works have already been completed. Please give me a fund so that I can make the money or pay the money to those officers.
Correct. If one engineer recommends illegally, doesn't
Sir,
mean
he's
that
the same engineer. He's the same engineer, same officer.
That same officer maybe, but
Can he? He's the same officer. Had it been a different officer, I can appreciate it. The same officer.
No, it's a team, Miller, which is inspected.
No.
It's a team. Your Lordship may say it's
No.
a team.
No.
Joint verification.
By whom? By him.
Joint inspection of the above work on so and so by the superintendent.
He is writing that. He has given a certificate. This superintendent engineer himself has given a certificate.
Completion and completion.
Let me decide. Let me decide on this. That this particular notion, whether it is permissible, is not. No. And 4 lakhs rupees, you can't make them run from one to another.
4 lakh or 40,000.
As in income tax, we know. Escapement is a change of opinion is not that escape the assessment.
Let me see, my lord, if anything proceeding might have been drawn up against that person. Let me just take instruction. You are taking grant to each
The
side.
counter affidavit has already been filed.
That's correct. Let me
Yes,
see
that's
if
there.
proceeding might have been done against that person. Or for what reason he stated it is completed. If it has been completed.
It is not disclosed, it is-
Work, Miller.
Mr.
It's
Mr.
the
Advocate General,
public work.
Mr. Advocate General, the counter affidavit is filed by the state. He has not disclosed that he has taken any steps against them, blacklisting him or doing something. Nothing has been disclosed. Can we go into this aspect now? After the affidavits are exchanged.
That is not-
The Supreme Court in this judgment has already said, once the counter affidavit and affidavits are exchanged, unless the court finds that the dispute which is raised requires to be adjudicated on evidence, the court should not shy away from deciding the same,
No,
the
I'm
writ
not-
court.
That I am not.
I was telling him that you go,
Also, that I am not on that proposition. A stand cannot be changed in a counter. But this document itself is clear. There is no change of
this
stand.
document sees the light of the day when he was insisting for the payment to be released.
Your payment is subject to the completion in conformity with the agreement.
Sir, the
So
work,
if a team cannot
the
implement
problem is
fine,
whenever, sir, there, if you come to that document, there are certain instances which are given. That is annexure 3,
that it is
completion
not-
report.
No, it is not the sole work.
No,
Another person
I'm just inviting your attention that why the change cannot be done. You look at it.
But EY5 also. Not rectified the works as per the.
No, I'm talking about that letter of 12th of April 2023, which is annexure 3 to the petition. Just- If you come, very interesting expression is used. In inviting, you have seen there.
A series of correspondences are there.
No. Annexure 3, page 16.
I have seen 16.
One thing why I want to- One expression I want to draw your attention. If you come, I request you to come. Please come to annexure 3, page 16. Have you got?
I am reading it.
Yes, in inviting a kind reference, certain amounts were there. For what? May be placed in favor of this division for as the following works has already been completed in all respect.
That's correct.
This expression in all respect, that connotes that there was no deviation. Had he not, otherwise he could have stopped completed. Why he said in all respect means taking into consideration the whole.
Defects pointed out by the engineer, by the employer or the principal is removed. That why should those people are not enemies? A joint team comprising of the engineers of the same division may not be, the same person may not be there. The authority superintending engineer, they might have found some.
Have you seen the signature? Have you seen the signature of both the documents?
Comparing, even if the same person can say that no, it is not in conformity with the agreement.
No. Cannot. I am just. Now I have to open my khata.
The legal proposition, I am not on that, it's purely a factual aspect. Legal proposition in such matters, in contractual matters, is a different concept altogether. It's not a question of Mahinder Singh Gill. Mahinder Singh Gill, Milord, if something is, Milord, there in an impugned order, it can't be supplemented by fresh reasons in shape of affidavit. But the document itself shows that it is not in conformity with the specification. Similar that principle, Gordhan Das Phanji and Mahinder Singh Gill, I am conscious of. 52 Supreme Court and 78, I am purely conscious of para 8 of the case. There is no fresh reason here. It rather, Milord, says that it is not as per the specification of the agreement. Let me take instruction, discuss with the secretary of the department. If it is due, it will be paid. Let me just find out what is the reason.
And
This
this,
is public work.
That-
Not only one, two works are there.
that
It is not
you-
4,80,000. There is also another 4,87,000. It is the same Aditya petitioner. Is the same person.
the.
It's
the
not
view-
4,86,000.
The
These
view-
are in respect of another work also the amount is pending.
The view is contrary to SOP.
That completion doesn't
SOP,
complete.
SOP. That view is contrary to SOP.
No, I'm not getting it now, right now. Anyhow, I will just see to it. But there are a series of judgments on that.
But I'm not.
And SOP also says that if there is any defect, then it has to be intimated to him and he is bound to rectify within 60 days.
It is that is what it is finding here. He did not, that is why I'm reading out those. That it was
Probably,
pointed out.
probably what we wanted to convey, please consider, if the SOP says that within 60 days, final bill shall not be released. Here it appears that you took 1 year time to go beyond the SOP. Even if only first correspondence that was made was after 1 year.
The D5 says so, within 15 days. D5.
No, please, probably that was the letter which you issued after 1 year of the completion. The date of completion was notified on 12/4/2023. Now, if you come to additional, the SOP is at page 10,
Rejoinder.
rejoinder.
Sir, 9.
That is your SOP.
An eligible payment due to the contractor, final bill. For works done,
SOP.
services will read from the
That
top.
is what is a processing. And once
That's
the
correct.
processing process is over, then it is completed. Then it is completed. He has given that particular photograph.
Says about the final running bill must have been paid.
No, it's the final bill. And that is at page 10, that relates to a final bill. All eligible payment due to the contractor for the works done,
Done.
services rendered and the materials delivered should be promptly settled. In all cases, the payment must be settled within 60 days after satisfactory completion of the work, unless otherwise mentioned in any contract. The timeline means for the timeline. The timeline for final billing and settlement of claim of the contractor shall be as under. Then he will submit the bill, final bill, along with the discharge certificate of the section. Then it says the creation of the final measurement along with the final bill has to be done within 20 days. And then if you find that there is this is not as per the specification, you can't. And then he has submitted the bill in the same manner because he has also submitted a photograph showing that he has completed it way back in 2022.
Standing assistant who will sign it. Mr. Tripat, have you seen the photograph?
So,
Who has signed it?
who has signed the photograph? I am asking you who has signed the photograph? Additional affidavit? It's the additional affidavit.
Rejoinder.
Rejoinder.
Bottom.
So the difficulty is that you are consulting the comments which you have received from your authority. You are not consulting the cost papers.
Here the one photograph is signed by the.
Signature.
Signature, have you seen the photograph? Do you have the copy? Look at it, who has signed it?
One is signed by the junior engineer, another signed.
Assistant engineer also.
Your
So
objection is your superintendent engineer says.
along with the
Yeah,
assistant engineer.
Consultant assistant engineer.
This is in respect to one document. That your lordship can kindly turn to the agreement.
That is the only work
comes
which he has done.
That your lordship may kindly turn, it is available. Your lordship may kindly turn to page 13.
30?
13. One
13.
three of the counter, the
Correct.
running page may be different. Orissa public, your lordship may kindly, this is the contract. Agreement. It is
Yes.
there.
Yes, yes.
Your lordship may kindly turn to
Yes. Page 13.
tender for works, page 12, conditions of the contract.
Clause,
Your lordship may.
clause
turn to-
number
I'm turning to 2A.
2A.
2A, it
Yes.
starts from page.
Yes, yes, I got it. It starts from
Time
page.
allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor and shall be reckoned from the date on which the written order to commence the work is given to the contractor.
Correct.
The work shall throughout the stipulated period of the contract be carried on with all due diligence. Time
Correct.
being deemed to be of essence of the contract on the part of the contractor. Shall pay as compensation an amount equal to half percentage on the amount of the estimated cost of the whole work as shown by the tender for every day, that the work remains uncommenced or unfinished after the proper dates. The work should not be considered finished until such date as the executive engineer shall certify as the date on which the work is finished after necessary rectification of defects as pointed out by the executive engineer or his authorized agents are fully complied with the contractor to the executive engineer's satisfaction. And further, to ensure good progress, your lordship may kindly look at in the bracketed place. The work should not be considered finished until such date as the executive engineer shall certify as the date on which the work is finished after necessary rectification of defects as pointed out by the executive engineer or his authorized agents are fully complied with by the contractor to the executive engineer's satisfaction. This is very important. That is what I was trying to point out. So therefore, once an engineer says it is completed, but it is the defect is pointed out, and that has not been rectified despite notice to the contractor, it cannot be deemed to be completed, even if he says it is completed. So therefore, your lordship may grant me a week's time. Let me talk to the officer, all that superintending engineer and the secretary of the department. If anything, it has been carried out in accordance with law, you will get it. I assure you not to let it be caught. Let me discuss with you what is it. Must be something there. Is based upon a contract, which is purely a commercial transaction. Lots of disputed, no, unless it is admitted. If I admit the dues, that those judgments period is not every fact, the case is decided on the basis of a fact. So here the fact is the engineer disputes the work has not been done. So it is a disputed question.
Now there are two aspects. Then question is, I must take
The credit of one thing. And so far as the APL international judgment is concerned, it is of a first kind. That we need to. It is of a first kind. Let us look.
But with the rule 47(7), let's. Let 15 days time, let's give my consent and let's 15 days. Deposit of the for amount lordship and I gave consent and because they are given the schedule lordship, you will charge. That's why they gave it 2 days left out of the cut-off date, let's say.
Oh, sir, that is that matter.
Let's say.
Adequate me to obtain instructions, specifically that after the successful bidder was issued with the intimation letter, he is supposed to deposit that security amount. He will give an acceptance, then the security amount within a period of 15 days. Now that 15 days, he asked for that amount. What would be the assessment of that amount? He asked 10 days after the intimation. Now that created delay. It was intimated on 16th that this is the amount which you are required to deposit. Then he writes 2 letters to the authorities that grant me 1 month time to arrange that amount. So finally, the authorities, they cancel, because he could not deposit that amount within that period of 15 days, that was given to the second highest bidder as per the rules. Second highest bidder could not deposit that amount. Then subsequently, they have issued the press tender, which is the subject matter of challenge. Your Lordship, last occasion directed me to specifically obtain instructions that even if that assessment is not given by the authorities to the petitioner, whether the L1 bidder can make his self-assessment and submit that amount. So on that, I have obtained instructions because those MGQ, royalty, everything is available in that tender document, so also in the statute. So he cannot take a plea that it was not within my knowledge, and since the authorities have intimated me after 10 days, so I could
What they should,
Yes.
if they can reasonably determine or assess the amount,
Yes.
there is no difference.
Your Lordship, para 6, they have narrated the entire fact, but para 6 is the answer.
Give me a copy.
It's an instruction, no? How
No,
can
no,
it be
it's
instruction?
One is a reliable document.
It's an instruction for today. Don't worry.
Yes.
We find that it has got some bearing, we will permit them to find.
To file affidavit.
Don't worry.
It's an internal communication, how can you file?
Para 6, Your Lordship, you can.
Probably I am unable to gather what he really wanted to say. Can you clarify this, that what is the what, because it's too clumsy. I am unable to have a clear picture of this. Paragraph 6.
But para 6.
What it really says, can you clarify?
Yes, yes. Before that, I take Your Lordship to this annexure 5. Annexure 5, page 49.
Lecture 5.
Page 49. This is the communication which he alleges was given to him after a delay of more than
Yes.
10 days.
Yes.
So this figure, if Your Lordship will find in the second tabular form,
Correct.
that royalty, MGQ, what would be the additional charge
Royalty equals to MGQ.
into
multiplied
royalty
by
plus
royalty
additional charge, then grand total, then EMD, and 1/4 of the security deposit. Now, if Your Lordship will look at 27.7, Lordship may kindly see 27.7. Rule 27.7 of the OMC Rule 2016.
Yes.
But Rule 6 deals with that intimation given to the selected bidder. Rule 7, within 15 days of such intimation, the selected bidder shall be required to convey his acceptance of the terms and conditions and to deposit an amount which shall be calculated in such a way
that it shall be equivalent to 1/4 of the total amount of royalty and additional charge and the amount of contribution payable to the District Mineral Foundation on the annual minimum guaranteed quantity taken together reduced by the amount of earnest money, which along with the earnest money shall be held as the interest-free security deposit. Now, now my lord's query was how
Correct.
he can
So
himself.
he has quoted a price for PUM.
Yes, and these price are available in the tender document. That is what tender document and this.
He has quoted a price because when you invite a bid,
Yes,
that means everybody gives his own figure,
yes,
and then who is the highest one will get it.
yes,
So he has quoted 2480 per cubic meter.
yes.
Correct.
My,
And according to you, let me understand,
yes.
please don't say yes.
I'm sorry.
If I am wrong, please say that no, this is not correct. You owe a very fair responsibility to the bench, so that there cannot be any confusion.
Right.
So if we go by this, so if he has quoted 2480 per cubic meter,
Well,
then according to you, the minimum guarantee quantity was which 30,000 cubic meter.
yes,
Correct?
well,
So he knew it that this tender is floated for 30,000 cubic meter.
well,
If he has quoted a price of 2480 per cubic meter, so he can simply multiply that price with 30,000 and he can arrive at the total amount.
yes.
Then the additional charges are is not quantified here. Then what could be the additional charges? How it is to be assembled?
My lord, additional charge is the amount which has bid over and above 360 because 360 is the minimum additional charge which is given in the tender document.
So according to you, then the calculation would be that the total royalty would be minimum guaranteed quantity, that is a 30,000.
Fine.
The royalty means
The minimum royalty
Yeah.
provided in the statute.
it is
35.
provided in the statute.
Yes, ma'am. It is there in the schedule to your lordship, ma'am.
Okay. So that will be there. Plus additional charge means over and above what he has said. So he has to minus that figure,
Yes. Ma'am.
right? He has to minus that figure. Or he has to add the total figure.
But by adding that 10% of royalty as per DMF, which is provided again in the tender document,
No,
lordship, ma'am,
I am.
Royalty.
No, his calculation is very interesting.
royalty is
No,
equals
his
to
calculation is royalty is 35 per cubic meter.
that is as per the statute.
And then he has added his price additional charge. So I
Additional
was-
charge is the highest quotation.
That means I was asking whether he should deduct 35 from 2480 or not. You said yes, but
I'm
it
sorry.
is not so.
Well, it's
That will
plus.
be added.
It has to be added.
Added.
It has to be added.
And this is what is you say that there is one fund, I think this
DMF.
District Mineral Foundation.
Well,
So this is DMF.
DMF. That is also provided at clause 10.1, 10.2, page 39 of the tender document.
That how should be?
Yes.
What would be 10%?
10%. The lessee shall pay an amount equivalent to 5% of the royalty as environment management and an amount equivalent to 10% of the royalty to District Mineral Foundation.
That's. Yes.
Lordship, can it come to rule 27(7) for a moment, Lordship? Again, on cost of repetition, I'm reading.
Please.
Lordship, kindly see. Within, Lordship, get it, Lordship.
Yes, yes, I'm.
Within 15 days of such intimation, the selected bidder shall be required to convey his acceptance on the terms and conditions and to deposit an amount which shall be calculated, let's see, in such a way that it shall be equivalent to 1/4 of total amount of royalty and additional charge, and account of contribution payable to the District Mineral Foundation on the annual minimum guaranteed quantity taken together, reduced by the amount of earnest money, which along with the earnest money shall be held as interest-free security deposit. So, Lordship, on the we are reading up this provision. So it appears it has to be calculated after declaring as L1, Lordship. Prior to that, Lordship, there is no such
That is what the confusion that came. You definitely raised the issue.
Lordship.
You say that, how can I know?
I'll come to
what
that.
should be the amount?
I'll come to that.
And how can I deposit?
Yes, Lordship.
The 1/4 as a security deposit unless they calculate and give a calculation.
Grateful, Lordship.
If it appears that
Yes.
there is a possibility of ascertaining the amount,
Yes.
and the formula is also given there, then if the party does not deposit, can he seek any equity in this regard?
Lordship, I'll convince Lordship. Then Lordship, kindly come to, this is the proposition of clause 27. Lordship, kindly come to their notice, what they've said. Lordship, that is it. Running page 47.
Where is
Lordship.
the schedule is you're talking about?
But that schedule is
Schedule, Lordship, that is at
schedule 2. That is where the new book, if my lords is holding that new book, that is
Holding this book.
my lord.
This is the book. Color is different.
112.
Same.
112, if your lordship may kindly see, is 112. Maybe it is same book.
Yes.
112. Schedule 2.
Color is different.
The lordship may kindly come to the next page, 114. Serial number 32.
What is the serial number?
32.
32.
Ordinary sand. Rupees 35 per cubic meter.
Yes, I got it. Go. Yes, let him on.
Let's then come to the page 47, Lordship.
Yes.
Lordship, this is the intimation will declare image successful bidder, Lordship. It can in consonance with rule 27(7). This is intimate that you have been selected as the successful bidder for the, Lordship, they have tracked out for release and described below name. They have given the name of the area based upon your application for the said period, the amount additional charge bid you have accepted to 2480 per cubic meter. Now strike up which is not applicable. The minimum plan, the mining plan and environment clearance for the said lease has been obtained. Public has not been obtained. Lordship, this they have not tracked out. It has not been obtained, Lordship. And strike out with the tentative selection is subject to the provisions of Amendment 2016 and to the terms and conditions annexed with this letter. Then, Lordship, second paragraph. You are directed to convey your acceptance to the terms and conditions and to deposit an amount as prescribed under Rule 1012, Lordship. They have not given this figure, Lordship, 1012. Then, Lordship, 1610 and 27.7. Then, which is not applicable. Proof of a deposit of apportioned amount along with the acceptance should reach the undersigned with 15 days of the date of issue of this letter. Failing with the intimation shall be stand automatically revoked without any further notice, and the bid security shall be stand forfeited. You are also directed to execute deed in respect of co-release, Lordship, for the aforesaid area within the period of sub-rule 1 of Rule 43 of the Orissa Minor Mineral Conservation 2016. Then Lordship, kindly come to forward 1012, Rule 1012.
Yes, yes.
Rule 1012. Here, Lordship, the selector bidder convey his acceptance. The selected bidder shall convey his acceptance of the terms and conditions within 15 days of such intimation and deposit a sum of equivalent to 0.25% of the value of estimated mineral resources, subject to a maximum of 10%, 10 crore rupees towards part of security deposit, and such deposit shall be held as interest-free security deposit for due observance to the terms and conditions of the prospective license come mining lease. Lordship, this condition, Lordship, is never the part of the document. Lordship, please, tender call notice. Then Lordship kindly come to, now there is another clause. That is, Lordship, 1610. Rule 1610. The selected bidder, it has been incorporated after this amendment, Lordship. The selected bidder shall convey his acceptance of the terms and conditions within 15 days of such intimation and deposit a sum equivalent of 0.25% of the value of the estimated mineral resources, subject to maximum 10 crore rupees towards part of security deposit, and such deposit shall be held as interest-free security deposit for due observance of the terms and conditions of the prospective license come mining lease.
Yes.
Then Lordship kindly come to another clause, Lordship, that is 27, Lordship, T. In case the mining plan environmental clearance for the purposes of lease has been obtained by the competent authority, this fact along with the cost of obtaining thereof shall be recoverable from the selected bidder, which shall also be mentioned in the notice. Then Lordship kindly come to Rule 43(1) also, Lordship. These are the amounts to be deposited as per the rules, Lordship, as they have been stated in their notice, Lordship. 43(1), Lordship, kindly see. Rule 43(1). Lordship, got it, Lordship? Execution and registration of license or lease. Yep, Lordship, may I read, Lordship?
Important data.
I'll come. These are the figures. Listen, they have given us.
Only after, it comes only after when you have complied all the formalities, you have complied all the statutory requirements, and then.
That is the part of the notice, Lordship. They have stated that is the part of the conditions and notice.
If there is any.
That's why the confusion, Lordship.
If there is any error, and if the error
Lordship
is not of such dimension that it will really wipe out every statutory provision.
No, I'm not on that, Lordship.
They will take an advantage of
Lordship,
this.
What
they intended is that they do not want to write more letter. Now, first you deposit, give your consent.
Lordship,
then I'm giving you a letter, deposit.
Lordship, in Odisha.
Then now I'm giving you a letter. You come.
No, Lordship, Lordship, in Odisha. Lordship, in Odisha, every action notice is supported with this scheduled chart, Lordship. None of the mining officer is giving this type of notice, excluding this scheduled chart. This is the exception, Lordship, perhaps. In every case, Lordship, can they say, Lordship, if I have deposited 1 crore, Lordship. Lordship, this is, Lordship, kindly see the manner of the notice, Lordship.
Also appended to the review. Which we have applied, in fact, page 49, the formula. In that case, sometimes the statute itself, the section contains a formula.
If your lordship.
Anyhow, this is difficulty, but what I find is that think about it for the future, that whether certain amendments can be given abroad, just to incorporate the
That formula.
so that there is no attempt to create a confusion.
It happens in every action notice, lordship. It supported with the schedule chart. In every lordship, let them file an affidavit. Any of the authorities, lordship, issuing such type of notice, lordship. In every case, lordship, the authority sending with schedule chart. That's why depositing. Lordship, that's why you made a clarification. Please give me the amount. Immediately on 16/6, they gave this amount, lordship. And lordship, within 15 days, I have deposited, I have given my consent, and I have shown the lordship banker's certificate that I am ready to deposit.
But that banker's certificate, if your lordship will find that is undated, that was never produced before the authority.
Can you file an affidavit?
You file an affidavit that
Yes,
you
I
are
have
produced before the authority.
I have come up with,
It has
I have
never
come up
been
with an affidavit, lordship.
That I have
I have
specifically stated.
let's
that
say,
instruction.
kindly see this. The government stand is very peculiar, lordship. I have quoted lordship 2480. E lordship kindly see the entire intent of the statute that only for the augment of the government revenue. And this is the maximum price, and I am the selected bidder. I am ready to deposit. Lordship can see the conduct. They only the vested interest. Lordship can record my statement. They'll come up with it.
Sir, I can understand your argument that they have a vested interest, provided they wanted to support L2 or L3. In this case, they did not. They did not, and now they have gone for an open tender.
Lordship,
Tender.
lordship,
Now you go and.
lordship, my officers, why I will suffer, lordship? Lordship,
Let us see, let us decide who's fault.
lordship.
Anything more?
No, lordship, I want to argue, lordship, because I want to argue, lordship. Because lordship, I want.
Any question?
Lordship, I want to argue because lordship, it is due to lordship the ulterior motive of the officer, a particular officer. Lordship, can see my entire lordship sequence of the events and my continuous approach to the authorities. And still, lordship, kindly see, I have given a lordship, kindly see, lordship, I have given a memo, bio of memo. My entire I have given the postal tracking and entire documents I have been given to the authorities. That is bio of lordship. Through their email, lordship, because it is a e-procurement, they have accepted it. The particular officer did not attend to me, lordship, and did not allow me to meet him because his vested interest to accommodate this query to a particular to his own choice, lordship. And that is not one case, lordship. Your lordship will find in every case, without the consent of this mining officer, no eligible bidders is lordship allowing to participate in the tender, or they are getting this contract. If there is some interest, lordship, kindly say, here I am ready with money and I want to deposit, and I have shown my every interest, lordship, to comply the order within 15 days. So that's why, lordship, my humble self before lordship, kindly again come to 227. This gives 15 days time. No, I'm not going, lordship, just I'm arguing before lordship. Section 27 has two parts, lordship. First is consent and second is deposit. And lordship, both the ingredients, lordship, qualifies 15 days. Lordship, kindly say they have given this figure on their own admission on 16/6/25, which expires, lordship, on 31st. It cannot, lordship, had it been a lordship, it is scheduled chart or there, it was knowledge of the bidder, why they issue this letter on 16/6, lordship? So definitely, lordship, this statute speaks of, lordship, it has to be calculated after declaring me as highest bidder, lordship. That is the entire language of the 27/7, lordship. And that's why, lordship, this officer, lordship, had it been the law, it is not a requirement under law, lordship, it is not required to issue me. He has issued this letter, lordship, on 16/6/25, and lordship, section rule 27 qualifies 15 days. The ingredients, lordship, within 15 days I can deposit. So that it expires on 31st. And further on 26, lordship, kindly see my letter, lordship, on 26, what I have written to him, lordship, kindly for a moment, lordship, kindly see. Prior to that, I have given number of correspondence, lordship, kindly to annexure 9, page 57. Lordship, I'm reading, lordship, 26 to in view of the advertisement dated 21/4/25, above mentioned source tender action through MSTC web portal on 30/5/25, our company, M.S.RAMAN Infraco Private Limited, Sambalpur, Odisha has been declared as highest bidder and accordingly intimation letter cum Form F has been issued on 3/6/25 by letter number 521 without indicating the exact calculated amount equivalent to 1/4 of total amount royalty, additional charges, and amount contribution payable of DMC, etc. in terms of Rule 27 of the OMMC 2016. Hence, on our acceptance and request letter, your good office only could intimate us for deposit of exact security amount by letter number 5 dated 16/25, granting only 2 days, that is 18/25, in contrary to the rules. For this reason, by way of letter dated 17/25 and 18/25, we had requested for 1 month time, which has not been responded till today. Though we are ready to deposit the entire amount of rupees 1,87,059 lakhs in view of the letter dated 16, but interestingly, your good office either not accepting or responding to the same. In the meantime, we are trying our best to contact your good office, but you are not responding at all. Now we have ascertained that with an ill intention, you are not responding and trying to accommodate second highest bidder in contrary to the terms of rules. Hence, we request your good office to accept the bid security amount as letter dated 16/25 in terms of Rule 27 of OMMC 16 to proceed with the further terms of the contract, for which we will be obliged. We look forward to your attention to this matter in prompt response. So, Lordship, they have given this chart on 16/6. It expires on 31st. We have given this on 26th, Lordship, and we are ready to deposit the entire amount within that 15 days. So, my humble summons, Lordship, the 15 days qualifies to both the ingredients, Lordship, for acceptance. And for acceptance, immediately we have responded and we accepted acceptance. That is on, Lordship. That is on 13/6/2025. So, and Lordship, there is no record under law to give this chart. Why they release this chart, Lordship? So the schedule chart, Lordship, if Lordship kindly see the entire purpose Rule 27/7, Lordship.
Yes.
Lordship, this is not the only amount to be deposited. And Lordship, the statute speaks of, Lordship, it has to be calculated, Lordship. So it is the Lordship up to the authority to make a calculation and to give me the figure which amount I will deposit, Lordship. It cannot be, Lordship. Lordship kindly say, I have read out, Lordship, 10, Lordship, that is Rule 10/12 and Lordship 16/10, and Lordship, I have read out also, Lordship, the provision, Lordship, that is 43(1), which, Lordship, all these three requirements they have incorporated in Annex 3. They are not saying it the deposit is isolation with the 41(3). They are saying, Lordship, all this amount has to be deposited, Lordship. See the tenor of the contents of this letter. This confusion, Lordship, because this is a defective order, Rule 27, Lordship, this Form F, which is issued by the mining authority. Lordship, 41, Lordship, kindly see the last paragraph. Lordship is absolutely correct. This 41(3) cannot be included because it is prior to the agreement. Because they have not come up with environment clearance, but they have not given indicator showing in the, Lordship, in the notice itself that whether the environment clearance has been obtained or not. But the fact remains it has not been obtained. So it will take another year, Lordship, to obtain that, Lordship, that environment clearance. And I will execute an agreement after getting the environment clearance. So the mining officer cannot include all those amounts in this notice, Lordship. That's why I prayed before him, please give the specific amount as per the schedule, which amount I will deposit. And Lordship, kindly see the contents of this letter. How can it will be, Lordship, it can be understood by a bidder that what is the amount to be deposited. So that's why none of the, Lordship, action inviting authorities in the state, Lordship, they are issuing such type of letter. All the notice, Lordship, including this notice and, Lordship, a schedule chart which has to be deposited by the bidder within 15 days. And that's why they have done it, Lordship, at Annex 5, Lordship, page 49. On my request, they have done it on 16/6. And this, Lordship, kindly see, they are giving this letter in consonance with the 27.7. Lordship, can last there you are direct to deposit an amount of prescribed rule 27.7 of rupees chetit within such and such period. So that is why it presupposes, Lordship, it has to be within 15 days from the date of issuance of this letter. So once it is issued on 16/6, Lordship, it is expiring on 31st. What I committed a mistake, Lordship.
Yes.
And this deposit, Lordship, kindly see, for again, I'm reading Lordship, Lordship 27.7, go for a moment, Lordship. 27, Lordship, that is 2 Roman 4, Roman 3 and 4, Lordship. These are two paragraphs very important, Lordship.
Yes.
Lordship, 3, in case a mining plan environment clearance for the proposed list has been obtained by the competent authority, this fact also with the cost of obtaining thereof shall be recoverable from the selected bidder, which shall also be mentioned in the notice. So this amount has to be recovered from me also, Lordship. This is part of the 27.7. Then Lordship, kindly come to 27.4, Lordship, Roman 4, Lordship. Income tax return previous financial year showing annual income of amount not less than amount of additional charge offered, and the royalty payable of the minimum guaranteed quantity of 1 whole year of bank guarantee valid of period of 18 months from the amount not less than the amount as above. So this bank guarantee already with them, Lordship, before participation. This qualification gives me, Lordship, the entire amount with the authority. I have given the bank guarantee. So 27.7, that's why, Lordship, has two parts. First, I will give consent. Then, after giving me the calculation, what is the amount, I will deposit within 15 days. But my understanding, Lordship, this 15 days, perhaps that is not there, Lordship, because execution of agreement comes much later of the completion of this procedure, Lordship. So it is up to the authority. They have the power, Lordship, to exonerate me, and Lordship, kindly say another provision I'm reading.
Yes, please complete.
Lordship, rule 29, Lordship, kindly see. Lordship, from 29. Environment clearance for grant of quarry lease, Lordship. Lordship, no quarry lease minor minerals other than the specified minor minerals shall be granted without approval of the appropriate authority under the provisions of Environment Act 1986. In Lordship, the competent authority may apply obtain environment clearance. In case the clearance under subrule 2 has not been obtained, the competent authority, the selected bidder, shall obtain the environment clearance before executing the lease deed. The lease shall be responsible for obtaining environment clearance and implementing the environmental management plan. So all are the requirement under law, Lordship. Unless we are getting an environment clearance, this agreement is never possible, Lordship. We can't execute an agreement. But Lordship, kindly see the contents of this 27.7 notification. The letter, Lordship. He has given, you pay those amounts also, Lordship. You come and as per. So this notice 27, Lordship, under Annex 3 is never in consonance with the 27.7. That's why, Lordship, rectified on 16.6. So, Lordship, if 16.6 the statute say, Lordship, it is have to grant 15 days, it expires on 31st, Lordship. Prior to though I have claimed for 1 month time, Lordship, that may be wrong, Lordship, request, because the perhaps this petition is honor of the law, Lordship. But letter within, consciously, Lordship, within 15 days, he is rectified. And has read it and is given the entire Lordship consent, and he is doing his eager, Lordship, they are not responding. Well, due to fault, because of defective letter, Lordship, because this letter, Lordship, kindly see the cost of difference saying this letter is never in concern 27. Lordship, kindly see for a moment they have come up with the rule 27. What are the language they have employed in the rule, Lordship? Lordship, for a moment, Lordship, kindly see. That is page 82, Lordship, of the new book, Lordship. Lordship, particulars. This is the Lordship, kindly say they have clearly written what are the provisions to be written in the Lordship, kindly see the letter what they have written, Lordship. They have quoted the entire provision of Lordship rules to make confuse to confuse the bidder, Lordship. They have given this letter, Lordship. And what, Lordship, prompted them not to give him the figure, Lordship, when the statutes say it has to be calculated. So definitely this is almost lies with the Lordship tender inviting authority, not to me. So Lordship, I have come with a very, Lordship, bona fide request, Lordship. It is, Lordship, definitely, Lordship, kindly say perhaps the Lordship, let it lie or let them complete the procedure, Lordship. This amount, perhaps nobody will meet this amount. Because somebody is against, Lordship, is not liking me, Lordship, because they will cancel. And Lordship, then file a Lordship where they have cancelled, Lordship. And Lordship, can the procedure of cancel must be there, Lordship. Law less speaks of, Lordship. There must be a cancellation. Lordship, can rule 27(9), Lordship. Lordship, if the first bidder fails, Lordship, they will give intimation to second highest bidder. Then, if the fails, Lordship, immediately compliance of the foregoing provision, the selected bidder, earnest bidder, refund the bank, 11th, Lordship. If the second highest bidder does not convey the acceptance within the time stipulated of such action, the e-action will be annulled and face invitation notice will such and such notice. Lordship, let them file an affidavit to write the completed this procedure, not, Lordship. My entire submission, Lordship, without making cancellation or without making intimation, when a bidder is ready to deposit, Lordship, they have ignored. And more especially, Lordship, I'm giving emphasis this 15 days qualification. Because this 15 days a qualification for both the ingredients, Lordship, for acceptance and deposit. So, Lordship, kindly consider, Lordship. There are many things to argue, Lordship, but Lordship, perhaps.
Let me.
That's why, Lordship.
You will understand that what dictation I should make in this.
And I have, Lordship, presume, Lordship, what Lordship is going to pass under, but Lordship. But my humble request is still, Lordship, to rethink, Lordship.
Let me confirm.
Lordship. So
Whether we are finished, you say it.
but Lordship, sorry, Lordship.
I think it will not percolate a good message to the juniors who are just.
Sorry, extension Lordship to pass, but I have left out a very good point, Lordship.
Tell me, what is the good?
Lordship, 32(2) for a moment, Lordship. 32(2) proviso, 32, rule 32. Rule 32, Lordship.
Yes.
The Lordship. The lessee shall pay to the state government every year dead rent, surface rent, specified work, and all the areas included in lease deed and royalty at the rate specified in the Schedule 2. Lordship might have the reference Schedule 2. Provided the rate specified in Schedule 1 and Schedule 2 may be revised by the government from time to time by an amendment made by the schedules. But no revision shall be made before the expired 3 days from such a Lordship. So the Schedule 1, Schedule 2 is revisable, Lordship. So it is, Lordship, definitely with the state government, because it, so definitely it is never, Lordship, kindly come to 3 also, Lordship. In addition to surface rent, dead rent, royalty, as the case may be, the lessee shall be liable to pay additional charge amount of contribution payable to the district mineral foundation and an amount of contribution payable to the environment management fund in advance on annual basis on the minimum guaranteed quantity of mineral minerals, even if the actual extraction falls short of such quantity. So my humble submission is that these amounts is never, because this Lordship amounts varies from district to district, Lordship. And this Schedule 1, Schedule 2, it is revisable. So it is never knowledge either in the statute or in the Lordship auction notice. It is never available to anybody to go to the Lordship to give the price which has been indicated under Rule 27(7), Lordship. That is.
The proposition of law
Online lesson, never disqualified, only they have revoked clause. No disqualification, only revoked clause as per that. Only the,
These are disqualified.
but
In that tender.
in let's
You have seen from the morning, the how, whatever, sir, whatever, sir, and all the hearing matters, no. We can take 3-4 hearing matters a day, but this time it consumed, you can't stop anybody from arguing. We'll see to it. We'll see to it.
Tomorrow, if I pray.
Let us see, sir.
Item,
There's not a time to mention, sir. Let us,
item number 3.
22, over matter.
let us see, let it be called.
Item number 3.
Look at it, nobody is sparing, everybody is arguing for hours and hours.
My negation is fixed in 3.
And if I become so strict that I will not permit you to argue more, I think that's a denial of adequate opportunity. But I think it's a collective responsibility. The repetition of the points are not appreciated. Yes.
Item 3, sir.
Item 3 is the execution appeal filed by the state. When the AG was supposed to argue, he was there in the morning. Or in another court, he is arguing one matter. Can I pray tomorrow? Only tomorrow morning.
I do not want to disturb tomorrow. Then in the next week, I will adjust one date. Yes, adjust one.
6th.
Yes, do it on 6th.
Item number 4.
Sure.
6th. 6th of
You have seen, you have been waiting that how tirelessly we have been put.
It's all right, no problem.
So,
Is it posted to tomorrow?
6th.
And when
6th. Next week.
it's July.
Yes. 6th August. July is over now.
As a past matter.
Yeah. Whatever. Yes.
Item 4.
This matter, the petitions are filed with petition, silently, action of the opposite department to. And if no action has been taken, action of the opposite department, but he may not, a poor matter. The what amount, 9 crores. Or some odd matter, 75 lakhs, and the opposite department of 4. Allotted the works in split up manner, 5 lakhs, without any tender. And that has been objected by the, you will also under answer 4.
Who is appearing?
State,
Can you split up?
yeah, no.
Can you split up?
In this matter, I am taking instruction. And for that, we can have a glance to actual file. Every year they have to this honorable court.
Yes.
And there's a 5 order in that. In advance, it was highly shared. There are I filed this date. The present petition. Yes.
Oh, that was he wanted to initiate a criminal proceeding against a public servant. Then he says, unless you take a leave or a permission, you can't do it. That is a different. Here he is saying that you have split up the entire work.
Yes.
So it's absolutely a different cause of action.
So for additional 4 instructions, I will issue.
How can you do it unilaterally? What is this going on? When For 2 weeks. Instruction 2 weeks. Filing of the counter affidavit, we can understand. Instruction 2 weeks. Take instruction within 24 hours or 48 hours. Next week, anytime.
Right.
Hmm.
Item 5.
Senior advocate appearing this matter.
What? What do you want?
Adjournment. We want adjournment.
2 weeks.
Item number 6.
Speaking, there are 2 matters. Both the matters we have received instruction and we have also prepared the draft counter. Also, may grant me 5 days time, I will file the counter affidavit and I will also serve copy on my end. It is already ready, but just the operating will put that signal. I will serve copy also on that.
What is that demand?
That demand is
Relating to what? The work already done, not made payments or compensation or what?
work not done, but they have demanded some money, my lord.
Okay, you are challenging that demand.
Yes,
How soon you can file your affidavit?
But 5 days. 5 days. So already
Within a week, rejoinder, if you want to file, you file it.
2 days required to file.
2 days, rejoinder. Matter to appear after 10 days.
Right.
Give a date.
Item 7.
May I please, Your Lordship, in this matter, petitioners are seeking direction from this honorable court to the opposite parties for establishment of the Kendriya Vidyalaya as proposed by the OP number 1. Lordship, kindly have a glance to the annexure 1, you know. With the commissioner, the OP number 1 is intimated to the Secretary Education State Government of Odisha so far as the establishment
We can't read it. Give me the original paper.
You have to file a type copy, fair copy. Whatever you receive, you just file it.
This is all darkened.
Is it
It's
readable?
very difficult. It's not very difficult to read.
Okay, you are a young man, but we have become old. Our eyesight is not good. I'm mine. I'm not.
I support. Very difficult to read. Can you imagine this document? How one will read? Why don't you give a typed copy?
Yes, Lordship,
Yes, sir.
Give, then what you are handing up?
I'm handing this typed copy, Lordship, legible copy.
You give it. We want that. Give another copy.
Yes, Lordship. It's the proposal for opening of new Kendriya Vidyalaya, the subdivision of Nilagiri in the district of Baleshwar, Your Lordship, by the OP number 1. Such thereafter, Your Lordship, there is a meeting has been conducted by the villagers, Your Lordship, and that has been a land has been volunteered by the villagers, Your Lordship.
Well, land has been
Volunteered by the villagers, Your Lordship. Such plot number, Your Lordship, kindly have a glance to page number.
Then what happened?
Thereafter, the petitioner proposed such land, Your Lordship. Thereafter, an inquiry has been conducted by the revenue inspector. And the revenue inspector, under Annexure 5, has given report that such and such position of such land and such land, the status of land is Gochar land and that may be de-reserved, Your Lordship. That may be de-reserved, and regarding that report has been given to the ADM, Your Lordship. Thereafter, there is no step has been taken by the government.
Under what provision this Gochar land can be de-reserved? Can you show me the provisions?
Odisha Government Land Settlement Act.
3A.
Sorry. PA.
Yes, yes, I got. Yes.
No,
Yes, Gochar is subsequently included by an amendment of 75.
75.
Yes, it is given. So what is to be done? What steps?
Yes, 22 no steps as we
Oh, we are asking him a question.
First time matters.
Past time.
Today it is.
Avoid this kind of I told many a times. Come with a concrete proposal, whether you are, because this is merely a proposal. It does not really bind the government. If for some exigencies, they can't have a right. But you'll have to take a decision, either yes or no. 2 weeks. Let them come.
Item number 8.
Yes.
This matter was heard in the last occasion extensively. Now the point here involved it on 27/12.
We forgot everything.
May I just recapitulate the issue? Here the point involved is the Odisha Minor Mineral Concession Rules 2016 was amended on 27/12/2022.
Mining officer.
Yes. So the question here arises after 27/12/22, the Tahsildar, rather the Revenue Authority has any jurisdiction to raise the demand under Annexure 16. And my lord wanted the notification copy of the 27/12 and produced.
Yes, who is appearing?
So far as we receive instruction, but that is the instruction is silent so far as jurisdiction is concerned. But in all fairness, my lords will see Rule 66 of the Rule 2016 it says about transitory provisions.
I think we have already gone against you.
Yes, that is what I was going to be.
Already gone against you. So how can he assume the power? Mining officer is always there to take steps. There is no problem.
I don't think this is the matter with that observation, my lord. If my lord, the mining officer can take who's needful, my lord.
No, that is it is within his competence. He can. There is who says that he cannot.
No, observation.
Observation, my lord.
What observation? That's the law.
Yes, my lord, only state that my lord, it is open by the mining officer to take.
Is open what? Should we remind him of his duty? Or it is his duty under the law. Why the court will remind them?
Are you pointing out at Rule 66(3)?
66(3). There is no provision. So far as the previous authority that is not mentioned. So I bowed out what my lords have already.
This we have not taken care of.
Yeah. No, we have taken.
But to that extent, I bowed down. My lord, in setting aside the Tahsildar's notice, my lord, I only claim.
I think that was a matter where we say that it will not apply for one reason, that the mining officer, he raised a demand, and thereafter the Tahsildar raised a demand for that period.
Here also
Same. So that was, it says that when the new system is not in place, then. And once the mining officer has assumed the jurisdiction and raised the demand, then the new system has put in place.
Yes.
Then how can he?
Yes, I totally bow down.
This is what is, we hold that.
period is same. Mining officer has raised for the same period.
Where is that?
That is Annexure 9, Annexure 10, sorry.
I'm exhausted.
Annexure 10 at page 54. What is page 54, my lord?
54.
54, annexure 10.
This the mining officer has done.
Yes. Sixth column, my lord, may I see. Is the demand amount in rupees for second year 22-23. Total amount is 2,529, and under annexure 11 series I have paid those amounts. Now my lord, we are going to page 80, annexure 16.
This is for second and third year.
Yes, for second year.
Second and third year.
So this is
Mining.
demand, yes. Thereafter also he has raised for the fourth year also he has raised.
Oh, anyhow, yes.
So page 80 is Tahsildar.
Yes, consider for the second year.
Second year.
How can he? When the mining officer has already raised for second year.
No. But my humble submission, because my lord, well, obviously, my lord will said this or not. My lord may only observe that it is open for the authorities to my lord,
Sir, while setting aside the same, then we'll have to what open the authorities. Now the difficulty is twofold. Mining officer has already raised a demand for second and third year. Tahsildar is raising a demand for second year. If the mining officer has already taken, then whether the Tahsildar can step. So what more it is open? It is up to the mining Tahsildar. Is a mining officer, if we want to
yes, my lord,
change that, he will do it. We will not make anything.
My lord, one line for my lord, if that observation, it is open to take. My lord,
Sir, it will be the greatest of injustice one can do. That will literally nullify their defense, which they have taken, that the mining officer has already raised a demand. That shows that we are impliedly reopening that it is not a final demand. And he can again review it and go for it. You argue on a proposition of law, we'll decide it. We will not go into this.
So far, the third and fourth year, my lord, I'm not saying, my lord, I'm not paying for any direction so far the subsequent years are concerned. But my lord, the second year, which is yet to be realized, my lord.
Sir, with folded hand, please apply your mind.
My lord, as my lord.
A mining officer has already raised a demand for second and third year. It is only after the mining officer raised a demand, Tahsildar raised a demand. If we say that it is open to the mining officer to do it, that means that demand is impliedly caused by us. Can we do it? If it is permissible to review, it is permissible to the mining officer to do it. Why we will make an observation?
My lord.
Consider it.
My lord.
It's called.
Item 9.
Just interpret this word. It's still the existing system is put in.
Item 9, sir.
This is a public interest litigation relating to construction of a multi-purpose cyclone shelter in that last occasion, Lordship.
You have to actually, this is a cyclone prone area.
Yes, sir.
There must be some.
In this matter, we have obtained instruction in this matter.
Related to silent.
You are not going to construct it.
Yes.
So,
Process has already started.
Manager directed to file an act.
he has come up. He has come up. He is accepting that yes, the grievance, the demand, I would say, not a grievance, it is a demand, appears to be genuine. Can we take it on record or you wanted to put it? Because this is what you are.
Like a time.
file an affidavit within a short period, nothing more. He has accepted. The meeting has already been held. The decision has been taken for a budgetary allocation so that they can go for, and it is not restricted to this area, anywhere which is a actually cyclone prone area. There should be some shelter because the peoples of that area must. So it's more a larger issue. Do it. The PIL, there is no concept of counter.
Item number 10.
Your lordship says, I apologize, the lordship is already sent for instructions and lordship. We have made a decision on the way to lordship. Next week.
Convince her.
Next week, your lordship, I will.
Convince her.
Yesterday night, they have approached me. Through telephone, they have approached,
Yes,
and they will take action today.
next week.
Right.
Good night, lordship.
Item 11.
Sometime during March 2023, the petitioner was given a work order by the National Highway Authority for upgradation of a 4-lane project to 8-lane project. One of the raw materials which was required for the construction of the National Highway project is black stone. Thereafter, the petitioner applied to the mining department for sanctioning a query in his favor for the purpose of extracting black stone. Where the process was started in 2024, and the petitioner complied with all the statutory compliances like mining plan, the necessary permission from the environment insurance, everything, my lord. And there was delay, admittedly, there was delay on the part of the state authorities in giving the required permission. And finally, a query permit was issued in his favor, my lord. That is under Annexure 7 at page 40.
Yes.
But as per the Orissa Minor Minerals Concession Rules 2016, a query permit can be given only for a period of 3 months, ma'am. So therefore, a query permit was given to him from 27/3/2024 to 26/6/2024. But despite giving the query permit, still then the petitioner couldn't have extracted the mines without having a blasting permission. Then he applied for a blasting permission. And finally, the model code of conduct was implemented for the general elections. And by the time the blasting permission came, the only 9 days were left so far as the tenure of the quarry permit was concerned. And thereafter, the petitioner approached the collector, and the collector thereafter requested the authority to extend the permit. I'll just read out Annexure 12 at page 49. Annexure 12 at page 49.
Then what happened? Then he requested the authority to extend.
Yes, sir. And all the facts have been narrated in detail as to how I have suffered.
Yes, then.
And thereafter, my lord, I submit Form S, stating that as per the mining rules, my lord, Form S is to be given if there is zero extraction. And that was also submitted, my lord. Under Annexure 13 at page 51, subsequently, my lord, the query permit was extended from 10/7/2024 to 9/10/2024. But thereafter, my lord, out of a bolt from the blue, my lord, I was asked by the mining officer under Annexure 18 at page 63 to halt the mines in view of 2 letters of the Forest Department. You know, kindly see Annexure 18 at page 63. The reason being, my lord, under annexure 19 at page 65, basing upon this letter of the Forest Department, DFO Cuttack, my lord, the mining operations were halted. My lord, challenging the action of the mining authorities, my lord, I come before this honorable court in a previous writ petition. Your lordship may kindly see annexure 20, page 69, the order dated 18/11/2024 passed by this honorable court, my lord. My lord, got it? My lord, your lordship would see, I just read out, it's relevant for the purpose of the list, my lord. Annexure paragraph 2, my lord. By order dated 4/11/2024, considering the peculiar facts and circumstances of the present case, this court had directed the state authorities to come out with a specific proposal for allocating an alternative site in favor of the petitioner for shifting its Blackstone quarry. Learned additional government advocate appearing on behalf of the state based on written instructions, which he has received from the office of the Deputy Director of Mines, Jajpur, Circle, Jajpur, has submitted the petitioner has applied for alternative quarry Rahatpur under Dharamsala Tehsil of Jajpur district. Feasibility study and preparation of mining plan is underway with respect to the said quarry. The DFO Cuttack Forest Division has been requested to verify the DLC forest status of the source. He submits that the matter involves public interest and concerns construction of national highway. The opposite parties shall take expeditious steps for allocation of quarry in the petitioner's favor, following due procedure and obtaining statutory clearances at the earliest. Thereafter, annexure 2 is the next order by God. That is order dated 6/1/2025. Paragraph 2, my lord. This lists this matter on 15/1/2025, and the court shall pass appropriate orders in light of the affidavit filed on behalf of OP number 4. OP number 4 is the Deputy Director of Mines of Vienna. And the relevant paragraphs have been quoted in the counter affidavit of the state. Paragraph 27, that in aforesaid premises, the statutory authorities with utmost promptitude have approved the mining plan of the petitioner so as to ensure completion of the time-bound National Highway project, and in view of the kind indulgence rendered by this honorable court to safeguard the public interest involved in the matter, it is now the solemn duty and obligation of the petitioner company to show its bona fide to discharge its part of obligation by commencing the mining operation at the earliest time. That it is humbly submitted that the issue relating to approach road of query Rahatpur is resolvable, and the opposite party number 4, DDM Jajpur, hereby undertakes to provide such approach road and so. And finally, my lord, the honorable court under annexure 3 at page 74 disposes of the writ petition. Well, paragraph 2, the last sentence on the ground. Paragraph 2, my lord, the petitioner has been awarded so and so, so and so. On the ground that the said query is situated inside forest reserve area, the petitioner has been restrained from carrying out the
Alternative site was undertaken then.
Yes, and a direction issued to see to it that the alternative query is provided to the petitioner, and necessary direction was also instructed to the other authorities to see to it that all the approval plans are given as expeditiously as possible. But thereafter, my lord, during this entire process when the matter was being adjudicated before this honorable court, at no point of time there was any allegations made against the petitioner that I was illegally extracting mines from the mining site Angira PSQ, which was given to me earlier. Nothing was brought to the knowledge of this court. Now, your lordship would see under annexure 25 at page 84, the writ petition was disposed of on 16/1/2025. 4/9/2024, during pendency of the writ petition, they say that they impose a penalty. They issue a show cause notice to me for imposing penalty of 20 lakhs of mods for illegal dumping of some minor minerals in my crusher unit. Thereafter, under annexure 26 at page 25, the penalty is imposition is saddled on me. Again, my lord, your lordship would see annexure 27 showcases is my reply. Your lordship would see. Finally, my lord, annexure 29 at page 92. Annexure 29 at page 92. They impose a penalty of 1,09,58,000 so and so, my lord, for illegal extraction of mines from the previous allotted query, my lord. And now under annexure 30 at page 93, that's very important, my lord. This is letter dated 11/6/2025. Sir, you are directed to deposit an amount of rupees 1,3,19,893 only as calculated below towards royalty and other government dues in respect of Rahatpur BSU. That is an alternative query which has been provided to me on the directions of this Honorable Court, my lord. But after asking me to pay the royalty, in the bottom, it is direct that you are also directed to deposit the penalties of 9 lakhs odd and 20 lakhs 35,000 odd imposed on you by this office related so and so, respectively for unauthorized dumping and extraction of minor minerals. And under Annexure 32 at page 96, the right to me that unless until this penalty which has been imposed on me, unless that is given, right, there is no alternative query permit has not been given to me till now. They say that the query permit is going to be cancelled. My respectful submission before your lordship is that can the authority club both the issues, especially when the alternate query was given to me on the direction of the due to the intelligence of this honorable court, because of the difficulties faced by me, because of which I cannot be put at fault by that. Now they're clubbing both the issues together, my lord. As a consequence, as a consequence which I'm not in a position to complete the work also.
Yes, did you commence the mining operations there? It was put at halt.
Nothing, my lord. Nothing, not even a single mine has been extracted, my lord, for which reason I submitted this. And therefore, my lord, in fact, I'll just take my lord to the letter of the collector, which also says, my lord, then just read out Annexure 12 at page 49, my lord. Annexure 12 at page 49. So this is the letter of the collector requesting for extension of the permit query.
True.
My lord,
After the extension was granted, I am just asking about it.
yes, my lord.
After the extension was granted, did you?
After the extension was granted, immediately the letter came from the DFO office saying that the mining area which was given to me earlier, that is coming within the forest area.
So how they found that you have stacked those materials?
So far as the stacking of minor minerals, that is for which an imposition of 20 lakhs some odd has been imposed on me, that is in the crusher unit. That is the allegation. My respectful submission before your lordship was that so far as the penalty which is being imposed on me, but I have a right to appeal against that also. Now they are scuttling that right by clubbing both issues. But there is an appeal provision.
So you go to the appeal, and so far as that part is concerned, if there is any.
So far as that part is concerned, I'll prefer an appeal. But now I have just shown my lordship that letter where they've said that unless and you don't pay this penalty, the permit is going to be cancelled. In fact, no permit has been granted in my favor pursuant to the direction of this honorable court.
So no difficulty. We will say that the permit, the cancellation is not there, but the demand would remain.
Let the demand.
It will not go. So if there is any shortfall anywhere, then they are not supposed to grant you a permit. Let us see.
Well, so far as the demand is concerned, there is an appeal process.
So you go, unless the appellate forum stays the demand. The demand stays at your face or over your head.
That's true.
Is a hanging sword. Is a hanging sword.
That's right.
And if they found that there is a default or there is a amount which is due on you,
yes, sir.
They will insist that you can't. You are a defaulter. You have to pay, and then we will grant you a permit.
No, but the statute does not permit that.
What?
Nowhere in the rules it stated that they can cancel the permit. Lordship, I'll just read out
was and this defaulting party will continue reaping the benefit in another place.
But as I point, but the alternative query which was given to me was given to me on the directions, and the query has not been given to me till date.
But the court did not anticipate that there was already a demand. Had there been a disclosure that there is already a demand, the court would have said that you meet the demand. But a person who is a defaulter and the demand is staring at his face,
yes,
then can't visualize. So unless mere filing an appeal does not tantamount to stay of the demand,
Yes, but my limited grievance before your lordship is.
is that,
As
that
of now.
you're saying that since the permit has not been granted,
Yes, madam.
question of cancellation does not arise. We'll record,
Yes, madam.
but granting the permit, we will not say anything.
Well,
No difficulty.
Well, granting the permit, they cannot withhold the granting of permit.
That you go, that what they can do in another avenue.
Well, they come up with an affidavit before this honorable court in the previous round of litigation, accepting that there is a public interest involved.
True, sir. There is no difficulty. I understood.
Yes, ma'am.
And very interesting thing which I noticed was
Yes, ma'am.
when you participated in a tender floated by the NH,
Yes, ma'am.
have you never realized that you have to use the Blackstone?
No, but I was conscious of it.
So once you quoted the rate,
Yes, ma'am.
you were conscious that you'll have to procure that particular Blackstone,
Yes, ma'am.
not from the mines, but from some other sources.
Quite right. Yes, ma'am.
Now you thought that if I have permitted to make a mining of the Blackstone, that would be a very cost effective to you. Not only cost effective, but it is also at the doorstep. You are having it in a nearby place.
Yes, ma'am.
So that is what you wanted. Does not mean that you will be granted a mining lease for that. I was really surprised with that. If they grant you, you are blessed. Where is the provision under the minor concession rules that you will be granted a quarry permit on this ground without following the other procedures?
Chapter 4 provides, my lord.
What?
Chapter 4 of the minor.
Without?
No, I have to comply with the requirements. I've submitted the mining plan. I've submitted all the statutory claims.
You are talking about a captive mines.
Yes, ma'am.
Or captive mines, because you wanted to use the entire minor minerals for your own use. You cannot sell it to anybody.
Yes, ma'am.
I understand. Then in that event, why? If there is something, then you will have to produce that it is not from that mines. I have not started. This is what I procure from the person who has been granted.
Accepted by the authority.
But we will not say that is the wrong on their part for cancellation. Maybe they mean that cancellation of the earlier one, which is put at halt. Putting at halt does not mean cancellation.
No, that tenure has also completed.
Then let's say that there was no mining lease, so you can't terminate anything.
I only pray before you.
No problem. We accept.
My only prayer is that they cannot drop the issue because they are cutting my right to appeal so far as the demand which has been made on me. Now, so far as the grant of alternative query in view of the directions of this honorable court, my lord, that has to be carried out in this letter.
Now you have made them wise. Now you have made them wiser, not wise. By coming to the court, you have made them wiser.
I'm the suffering party, my lord. Without the Blackstone query, I'm not able to finish the project.
You can procure it from there. You can.
I don't have a query permit, my lord. I cannot.
Oh, you can buy it from the market, can't you?
My lord,
for that, only the permission is required. Nothing more than that, can't you? If somebody has been granted the mining lease, if he's extracting, if it is not for his own consumption, he can sell it. Where is the difficulty?
Can the directions of this honorable court, my lord, can it be avoided by them, my lord? They assured the
direction has to be in tune because at that point of time there was no demand.
So therefore, my lord, it was their duty because they say that I have extracted illegal. I have submitted Form S. They have accepted Form S. Form S is to be given when
that will be decided by the appellate forum. Go there and if they stay, we will quash it. Which is the letter? We'll quash it. There is no mining lease. How can you terminate it? Threat. Where is that? Which letter is under challenge?
It's 92.
My lord, Annexure 32, 47/2025.
96.
Annexure 32 at page 96, my lord.
Is challenged.
Along with Annexure 29. But so far as but I'm only agree with the clubbing of both the issues, my lord. And nowhere in the concession rules, my lord, such a step can be taken against me, my lord. They can
This
prosecute
is
me under the
Anjira BSQ is the earlier.
earlier one.
Okay.
The letter on which they assured this honorable court is Rahatpur mines. And for that also I have submitted all the statutory clearances, mining plan, lordship would visualize the hardship I have gone through.
When permit applications shall be cancelled, it does not say the permit. You have
Query permit application, my lord.
you have given the impression that the query permit is going to be cancelled.
I'm sorry for that. So for application again, my lord. Can they cancel? Can they club both the
You
issues?
were very emphatic
No, my lord, I'm sorry.
that when there is no permit, how can they cancel? You proceeded on that basis.
My lord, I'm sorry about that, my lord. Sorry about that. Probably I misread that, my lord.
This is not expected. This is not expected.
My lord, I misread that, my lord.
No.
Query
You
permit
know it
application.
very well, sir.
No, my lord, that's true, my lord. But my respectful commission, my lord, I just bow down, my lord.
It's not that I was there for nearly 19 and a half years.
No, my lord, I misread that, my lord. Misread that.
I know why it has been done and what purpose it has.
I misread that, my lord. I'm extremely sorry about that. But so is the application, my lord. I'm only my grievance is that they let them not club up both the issues, my lord.
Like maybe you were saying, but you were arguing in a different fashion. You were arguing in a different.
No, my lord, I completely misread the last time, my lord. Application, my lord. Your query permit application shall be cancelled.
File your affidavit. Giving you an opportunity. Yes. File by 3 weeks.
Item 12.
My lord, may I only
No,
make
nothing.
Item 12.
my lord, at least let them process the application, my lord.
Nothing.
No, I'm sorry about that, my lord. I completely misread that particular line.
Item number 12.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. P.C. Das. So due to illness, he could not appear. We need an adjournment. That is very close. 2 weeks.
Item 13.
Okay.
13.
In this case, the petitioner challenges the exchange.
180 ml you want?
Mile.
180 ml.
Mile. Identical numbers of identical methods.
Item 14.
You are appearing earlier. So where this concept of 180 ml evolved? I am really surprised, though I am following it covered matter, but I am really surprised.
ml, 60
No,
ml.
the order is that permitted to lift 180 ml. From where this concept came?
180 is the
What is the rationality?
What is the rationality? 180? Why not 750? Why not 1 liter? Why not 5 liters? Why not 10 liters? Why not 90? Only 180. Why?
There is 90 and 60 also. 90 and 60.
No, the order is that they say only 180 ml is permitted to be. This concept of 180 is really unknown to me. So where this notion is derived?
From the first petition. First petition.
Who had approved this code where the order was passed, he must have claimed only for that.
That.
So that is being followed in all other cases. There may be requirement of 90 or 60, but everyone is saying 180.
Really surprised.
Second class, then. You know, that's
What is the subject matter of challenge? Why it has been confined to particular?
you tried in any one of the cases.
We wanted to decide this matter. I don't choose any one.
Yes, Your Lordship.
We wanted to decide what is this? How can you restrict it? I think he appears frequently in those matters. No, there is another. Where is he?
He's PIL, Your Lordship.
No, there is another gentleman. He appears.
Mr. Patra. Mr. Patra and.
No, we are also appearing that matter, Lordship, that is their notification. Some of the cases I
Some
may.
matters, no, for me.
No, choose one matter, we want to decide it. What is this concept of 180? I do not know rationale in between in that.
The policy that they have restricted.
No, what is the policy must be rational, reasonable. You either you say that so far as this IMFL shops are concerned, banned. Welcome. No difficulty. There will not be any sale. But if you say that yes, I can't ban it, you sell it, how can you restrict the quantity? Can you say that a person will not purchase one bottle? You can't. If you say he will buy 50, and if a larger amount of the liquid is put in a bigger vessel or a bigger one, then at this bottle, then the costing is also reduced. If it is bottled in a smaller one, then the costing is also high. So what do you gain?
It's actually for restaurant and bar purposes, Your Lordship.
I don't know what is this. The rationality behind it, that 180, every time I think 100 more than, since I came here, I think I have dealt with near about 300, 400 cases of 180 ml.
I do that more than 1,000, let's see.
Anyhow, please find out
Yes,
one.
Your Lordship.
whether I
We
want to
will,
decide.
we will.
Find out, give one matter, let's decide.
Item 14.
Please, Your Lordship. It's a public interest litigation relating to the improper functioning of the State Consumer Commission due to dearth of stenographers. And since January 2025, there is not a single stenographer present before the commission. The members are forced to write the adjournment orders by their hands, and all matters are getting adjourned. The judgments.
I appreciate that your sentiments, your agony, your sympathy for the members of the Judicial Commission.
That they have
You are
themselves
so
written.
perturbed that somebody is writing in the hand.
That they have themselves written to the Chief Secretary, my lord, page 11.
Why you are espousing their cause?
Because, my lord, I am.
Are they not competent enough to espouse their own cause?
That they are not doing, that is why I have to come, because the petition.
PIL is only when the persons who are underprivileged, unprivileged, they cannot come to the court because of the economic disparity or the economic stringencies. Then somebody can espouse their cause. They are more solvent those members are drawing enumerations, I do not know whether salary can be used as a good term. You are so
My-
sympathetic to
Now, my
them.
locus, if I may kindly explain, the petitioner is a widow lady whose husband died in COVID, leaving two minor children. Her insurance claim was rejected. She filed a case before the district commission where it was allowed. Now her case is pending before the state commission. The judgment is reserved since more than 1 year.
So for that PIL,
So my lord,
if they can write a judgment or order by hand, they can write a judgment also by hand.
that is what they have disclosed, that we are incapacitated at
No,
page 11.
No, that can't be a ground. If it is a ground, then we will definitely issue.
Kindly,
227 is the
Yes.
mode, not PIL.
yes.
A power of superintendence, not the PIL.
My lord, may
We
kindly,
will be doing, we will be encouraging this frivolous PIL. You show us the ingredients of it.
my lord, I'll just show as to assist your lordship only on this, that I am not a busybody and how I can.
I am not saying you are a busybody, but
Right.
can you spouse the cause?
Right.
When I am giving you
Yes.
from a Bachpan Bachao, when the Supreme Court has started
Right.
the concept, it is the remedy, not from the statute, not from the constitution.
Exactly.
It is a judge-made remedy.
Just made.
And if
Exactly.
it is a judge-made remedy, then the court will definitely.
Exactly.
No.
On this one judgment, para
If you
32,
come argue, you decide.
only para 32, your lordship.
That's the only judgment you want to cite.
Yes, your lordship.
I will dictate the judgment today. I will-
Only one paragraph I'll read.
I will take this and I will read a judge, I will dictate a judgment with consent of both, that I may rely many judgments. So it will be from your mouth, please.
Then your lordship may kindly grant me an opportunity to file further judgment. His lordship is reserving me the judgment. So, because I have not even read out this judgment. Yes, your lordship, then I.
That this is the fact and the PIL is maintainable.
Yes,
I know the judgments that the locus standi in a PIL is not a matter.
Yes.
The court should not insist, I am conscious. But the purpose for which the concept of this PIL emerged, if this is the fact, I think the purpose is shattered.
I have nothing personal to gain from here. My prayer is.
Sir, if you wanted to really settle your own personal grievance or settle your score, by this method, you wanted that your judgment would be delivered immediately.
My prayer is just for appointment of stenographers there.
Very easy. What cannot be achieved directly is sought to be achieved indirectly. That principle is also there. You are taking a circuitous route to achieve something which you cannot directly come and take. It will say so.
I'll supply further judgments.
Yes.
I'll research it and further.
Please. Probably it originates from 1980, this concept of PIL. We've not see.
1978 one judgment. So I'll.
There, practically 1980 it originates. Yes.
Another date may be given.
Any time which you feel is
3 weeks.
sufficient for your research purpose,
Yes, sir.
tell me.
In 3 weeks after, I'll give all the judgments in a compilation. 3 weeks after.
Item 15.
The matter millers. Person directed an arrangement to take instruction for grant of refund millers in respect of excess of realization income tax over and above 20%, which is directed by the civil millers to pay during penalty of
We remember.
Right.
And in this case, my humble solution that RCC has never approved the department with evidence of payment and refund adjustment amount. who is, it is entitled, so this will pass.
Now he has approved the court and make you to appear, what further approach will be made? Or more?
Department.
Department. If the entitlement is not denied, then he is entitled to a refund. You can't,
Judgment.
use the amount more than what is declared.
I don't know, I'm bound by what one now.
Three judgments of there for Delhi, of Delhi High Court. And also will also.
No, no matter, actually, the adjustment of the excess amount is being, the section 245, that has not been complied. That there's so much CPC that has been adjusted, excess amount.
No, asking you, can you, when they have gone for the fees and the. What there is already an office memorandum of 2017 saying that you can't.
Correct. And once 20% deposit bills, the entire remaining amounts are remain straight in disposal of appeal bills.
That is what I'm saying.
Correct, Milord.
These are the statutory one, the moment he deposit, can you go and take it beyond that? Perceiving that yes, there will be a demand more than 20%. Can you presume? If the statute says that up to 20 or 20%, not beyond it, and the office memorandum also says that it can't, then what do we? Refer. Refer them. Mr. Kedia is in a confused state of.
Lordship, the department, Lordship, in this case, department has no fault. What they, once you file an appeal, you have to approach to the assessing officer for refunds, for a stay. When the stay, he filed a stay petition, within that day, he has not deposited that amount. He intimated on 20/11/2024 about the adjustment. But prior to that, this refund has been adjusted by the CPC by giving information in section 245. 3 times, the 3 years adjustment has been done according to your lordship. And they have informed.
This cannot be done as per your own
No,
order.
lordship, they have to inform that they have deposited 20%, but stay has been granted. After getting that information on 20/11/2024, no adjustment has been made, your lordship. No adjustment, no further amount has been, no notice has been issued for the refund.
Can't keep the amount, refund.
Do you like it? Some. How do you do it? Choice is yours.
No. It's a broken interest case. I mean, if there are any, you know. That office memorandum of government.
Yes, that I have annexed bills. Right, annexed bills, annexure 5, yes. Page 44, yes.
No, June, I wanted the, it's not June, 29th of February 2016, amended by 31st June.
Yes, yes.
Sorry.
2016 circular says it's 15%, now it is by 20%. But in case I come under,
Para 5. Reference is made to.
para 5, yes.
Yes.
If, correct. So I have given to it.
Because it says that in paragraph 4A, B is the only option where they can, otherwise they cannot.
Absolutely. If I fall under 4B below,
This is
then
what
for the
I wanted.
correct. Then for the reasons recorded in 4B says, my lords, supposing in a given case, there are judgments by Honorable Supreme Court or High Court which are against me, my lords, and in favor of revenue. Sorry, my lords, be capital B.
It is actually not.
Yes.
Annexure 4, page 40.
He says
Yes.
That my lords
that's
have
only
said.
the 20 and 15%.
Yes, sir.
Yes.
But this B is there that he can, but provided there is a decision of the Supreme Court.
Correct.
Or a jurisdictional high court of the SSC.
And they have to be lords give reasons before invoking B, capital B.
That is what is the judgment of Delhi.
Absolute correct, my lords. They have no point of time. This is either their case nor they have it.
It was also a case of an adjustment under section 245.
That also mirrors, they have, barring one, they have not given any reason, nor 245 intimation, they have never issued. Barring only one.
No argument.
Just I was giving explanation, your lordship. And what once where appeal is in filed, you have to file a stay petition. In stay, the stay was granted to pay the amount within this day. He has not paid that amount. Then again, when he filed his return, the refund was adjusted by CPC by intimating the SSC. We propose refund has been generated. We are adjusting with the outstanding demand. If you won't reply within 21 days, the refund will be automatically adjusted. In this case, all the refund was adjusted prior to giving an intimation to the ITO.
No,
So
that has been refuted.
we don't have any fault
Barring
with
one.
ITO. So they have intimated to the ITO on 20/11/2024, your lordship. We have the letter also.
Make a refund.
In annexure 14 on their own, they also say. Page 77, they say you have paid 20%. They don't say you have paid excess of 20%. So the outstanding demand is granted, is stayed till discharge of appeal. They don't say you have paid more. Even if they have realized more, they said you have paid 20%, don't pay for the demand is stayed. But I have already paid me 21,43,181 as per my. 48 lakhs I have paid, appropriating 27 lakhs, 20% bills, balance refund excess collection comes to bills 21 lakhs. That is what Honorable Delhi High Court said, you pay that much. Even if authorized, as my Lord Honorable Justice Raman was saying, LG Electronics, Supreme Court said 20% is also not a fetter. That we are not here challenging, but authorized also you could have contested and reduced also the percentage. Otherwise.
There is no hard.
Exactly correct. Right. But the distinction between 220 subsection 6 and the board circular now is board circular say pay, gets stay till the dismissal appeal. But 220 subsection 6 only treats the assessee not to be different, subject to satisfying the conditions that may be imposed by him. But here CBT says pay 20%, balance remains stayed. And that 20% your lordship says Delhi High Court and Honorable Supreme Court says is cannot be a fetter to the judicial discretion available on the 220 subsection. You can't interfere with the discretion of the appeal. Correct. That's what the
No notice has been issued.
No.
public matters.
No, stage we wanted. Spending, I know. Stage.
notice for hearing.
But now it is faceless. We also don't know where it will be and how it is. My lords knows faceless is a cloud where nobody can. And so typically the arrangement, your lordship will be surprised not. If I file appeal, that will go to the faceless unit. They will transmit it to any other appellate authority. They will pass a draft order. That will again be back to the center where it is sent. After it is finalized and again sent back to the appellate unit where I have filed. They are only communicating, they will communicate, that's all. And it's a very vicious circle. That was challenged also. I think the PIL is before your lordship by Patak Chakra.
Draft order comes to you.
Draft order, no. Draft order comes to center. Faceless center. Sorry.
You use the word VCS circle.
VCS means.
So VCS circle connotes something different.
I understand. But here only thing was that the right of, as your lordship knows, the opportunity of.
Generally used for a person. A man is known for his VCS circle.
Negative word.
Negative, always.
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 This is a cumbersome.
Cumbersome, right? Absolutely correct. So no interaction, facial interaction, nothing else.
The reason is that you know better.
Objectively audible, that is good. Doesn't really do.
That is what is good.
With interest mirrors, Honorable High Court has also.
No. This is what. Delhi High Court has said 4. The Manmohan's judgment is that within 4 weeks. No interest.
I think some High Court somewhere I have seen.
Maybe, but we are following the Delhi.
Fine.
Delhi High Court did not. Because the difficulty is because they have just against the liability for us. So if it is refunded, then that liability remains revised or open. Then they are liable to pay.
Yes. Because the refundable amount carries interest. Had I got a refund till the date of getting refund, I am entitled to interest. Now that it is adjusted, that period I am going to.
So you will have to deposit the amount of they have ascertained the quantum of the tax for a subsequent year where the adjustment has been done. Then in that event, will they not pay? They do not pay.
The lordship on the 245 are proposing a refund which has been granted in which that interest is also been adjusted. And interest is also
Interest till the date of
adjustment.
Yes, till that date.
That was in the subsequent assessment. You have adjusted for the disputed assessment year or
disputed assessment. 1819, all the refunds which have been flowed for the 22, 23, 23,
where you have adjusted.
Oh.
Adjusted in the subsequent assessment year or what?
For this period for which appeal is pending, Milords.
This period?
Yes.
18. So they have adjusted against the demand more than 20%.
Yes, more than 20%.
I was thinking that.
No. Para 17, Delhi High Court will have.
Then it's on.
Right.
I was under the different impression.
No.
So. Yes, call this.
Item 19.
Minutes, item number 19. This is regarding the validity of the notification under section 168A minutes. The batch of writ petition is pending before your lordship and similar order.
Guwahati High Court has been decided. Kerala High Court has decided.
So let us fix a date.
Your lordship.
We can.
The batch was listed. That is my friend.
Against the judgment of Delhi Honorable.
In the meantime, Honorable Supreme Court that is.
Item 20. Item 21. Item 22. Item number 23. Okay. 23.
I am for the appellant. It's a cooperative bank, and we have challenged the order of Honorable Single Judge. Order of Honorable Single Judge of High Court of Orissa, on the ground that the factual position was not. Here, we have challenged the order of Honorable Single Judge of this High Court. Controlling authority by whom? Controlling Joint Commissioner come appellate authority under payment of gratuity.
So you were the petitioner in the writ petition. Your writ petition is dismissed. Yes.
The only ground that we have challenged that the factual aspect was not elaborated in the judgment portion of the judgment. So, and
does it make the judgment absolutely illegal or erroneous, or
my humble
if the relevant facts are taken into account? Can you say that no, every fact which you have pleaded must be there in the judgment?
Not that way, but only factual, which is most critical of the situation.
Just show us that this is the finding which is there. He has not considered this aspect. If you can show that this is what has been observed, but I have already explained in my petition, he ought to have taken into consideration. We can appreciate.
In the where he has dealt that the factual matrix of the case, he has very elaborately mentioned about the factual position. But in the judgment portion, he has not uttered a single word why he has not considered that aspect.
Who?
Honorable Single Judge.
Single Judge has taken.
So on the judgment portion, he has not mentioned that is, madam. Dismissed. That case was dismissed.
Just take the note of all factual aspect. Then you want again he not to have.
No. So therefore we have come for this writ application. But reasoned order. I only
reasoned order. What is this paragraph 11 onward? The reason is given. The paragraph 11 onward, the reason is given.
He has only cited the presentation of the advocate. Presentation of the
No, sir, paragraph 11 onward.
Beg your pardon. Yes, sir.
No. What more reason one should expect? The reason may be wrong, the reason may be erroneous, the reason may be infirm. But you have to demonstrate the reasons. But if you say it is bereft of reason, it will not find so. He has given. You can't say there is no reason. From paragraph 11 onwards, we consume nearly 15-16 pages to give a reason.
That's okay. He has only mentioned what the presentation, what the learned counsel has presented.
If that is the only ground, then
As
that's the only ground.
and the pendency of criminal cases and civil
How
cases.
it will impact the liability? I just asking. What is the nature of the criminal case?
That respondent source, who was an employee of the bank, so he went on committing series of financial irregularities, siphoning of depositors' money, misbehaving the elderly lady customer, and on intoxication stages during office hours. So 5 proposed notices have been communicated to him. 3 disciplinary proceedings have been initiated. 1 disciplinary proceeding have been closed. 2 disciplinary. And while vigilance cases are pending, I am presenting the present status of vigilance.
Is there any statutory rules that in the event the disciplinary proceeding is initiated against the delinquent or his retirement, he will not be paid the gratuity, he will not be paid the retirement benefits, he will not be paid.
So, Gratuity Act doesn't permit the employer. If the employee is terminated, then the Gratuity Act empowers the employer to forfeit the gratuity. But with regard to superannuation, with regard to other benefits like leave salary, as per the staff service rule, that is permissible, but not Gratuity Act.
So, this is under the gratuity.
My lord.
So you'll have to pay. If there is no statutory fetter, how can you prevent?
As my lord decides.
Sorry. You are an appellant.
So
You
therefore,
cannot say.
I am. It is my humble submission that since he is criminal,
There must be some provisions. In absence of any provision, can you? This appeal arises from a judgment dated 9/10/2024, filed by the single bench in the
You have consumed the whole day. Item 50. Item 25.
Kindly taken